Hi guys! Welcome to another episode of Attorney Javier's Philippine Law Lectures for Students. For today's discussion, we'll be having the last episode of my series on the Anti-Money Laundering Act of the Philippines, or AMLA as amended, together with its Implementing Rules and Regulations, or IRR, and specifically, I'll be discussing the legal remedies under the law. So if you like my videos and you want to see more, please hit the subscribe button. Also, please remember that this is only for educational purposes and is not a substitute for proper legal advice or for studying and understanding the law. Now, a like on this or any of my other videos would also be greatly appreciated. Now, let's begin. So far in this series, we have discussed an overview of the crime of money laundering, obligations of covered persons, unlawful activities, and other related matters. Now, let's say there are certain acts which give rise to a reasonable belief that money laundering has been committed. What happens next? What are the legal remedies under AMLA? In general, the legal remedies under AMLA include bank inquiry to be conducted by the Anti-Money Laundering Council, or AMLC. We also have a freeze order, civil forfeiture proceedings, and of course, prosecution of the money laundering offense itself, which carries with it criminal forfeiture, without prejudice of course, to prosecution for the unlawful activity or predicate crime which gave rise to money laundering. Now, for lack of material time, and also because it is highly likely that future amendments may change the law, I will not be discussing these legal remedies in detail. Instead, I will only give an overview and note that these remedies are current as of the time of this recording in July 2023. So, let's begin with the simplest remedy to discuss, which is the criminal prosecution of the money laundering offense, which carries with it the legal remedy of criminal forfeiture. Now, as with all other Philippine crimes, the remedy of criminal prosecution begins with the filing of a complaint before the Department of Justice in case of private individuals, or before the Ombudsman for public officers or private individuals in conspiracy with the public officers, as the case may be. Now, the DOJ or Ombudsman will determine whether probable cause exists to warrant the filing of a complaint before the Regional Trial Court or Sandigan Bayan respectively, and then trial will proceed with the prosecution having to prove all the elements of the money laundering offense charged beyond reasonable doubt. Now, if the RTC promulgates a judgment of conviction for money laundering, it shall likewise issue a judgment of forfeiture in favor of the government of the Philippines with respect to the monetary instrument or property found to be proceeds or related to the unlawful activity. However, remember that as previously discussed in the earlier episodes, prosecution of the money laundering offense is separate from prosecution from any of the predicate crimes which gave rise to the money laundering. Meaning, the predicate crime such as kidnapping, destructive arson, etc. will be filed and prosecuted as a different separate case from the money laundering case. Now, before a crime can be prosecuted, one must first know or at least have a reasonable belief that a crime has been committed. And how do you do this? This is done through investigation. So one such way to make prosecution possible is through the power of bank inquiry. And bank inquiry is simply the authority granted by the AMLA to the AMLC to inquire into or examine any particular deposit or investment, including related accounts with any banking institution or non-bank financial institution. to review the discussion in episode 1 of this series, conducting such a bank inquiry does not violate the secrecy of bank deposit law or similar laws because AMLA is expressly made an exception to such laws on privacy and secrecy. Okay, this is for the purpose of preventing, prosecuting, and punishing the crime of money laundering. Now, how is this bank inquiry conducted? There are two ways for the AMLC to inquire into bank or investment accounts, either by applying for a bank inquiry order with the Court of Appeals or CA, or in special cases, the AMLC is allowed to conduct the inquiry by itself. It doesn't have to apply with the CA for an order. Okay, so first, generally, to conduct a bank inquiry, the AMLC has to file an ex parte application with the CA, which has 24 hours to act on that application. Now, the CA will only grant that application and issue a bank inquiry order if it finds probable cause that the deposits or investments involved are in any way related to an unlawful activity or money laundering offense. However, a court order is not necessary if probable cause is shown that the deposits or investments involved are in any way related to the following unlawful activities: kidnapping for ransom, certain specific violations of the Dangerous Drugs Act, okay, such as selling drugs, etc., hijacking, destructive arson and murder, and similar felonies punishable under the laws of other countries, and terrorism, conspiracy to commit terrorism, and financing of terrorism. So, if there is probable cause that the deposits or investments are related to any of those unlawful activities, instead of applying for a court order, the AMLC can conduct a bank inquiry on its own. How? By issuing a resolution authorizing its secretariat to inquire into the deposit, investment, or related account. In either case, once the covered person receives the bank inquiry order or the AMLC resolution, as the case may be, then the covered person must give the AMLC or its secretariat full access to all information, documents, or objects relating to the deposit, investment, account, and or transaction. It must also submit certified true copies thereof within 5 days, and they have to keep the inquiry confidential in order to prevent tipping off so that the criminal won't run away with the dirty money. Next, we have the freeze order, which is a provisional remedy, meaning a remedy in the middle of the proceedings, with provisional remedy aimed at blocking or restraining monetary instruments or properties related to an unlawful activity from being transacted, withdrawn, deposited, transferred, removed, converted, concealed, or otherwise moved or disposed without affecting the ownership thereof. This is actually a targeted financial sanction which seeks to prevent funds or other assets from being made directly or indirectly available for the use or benefit of any person or entity designated by the United Nations Security Council resolutions. Okay? So when we say targeted financial sanction, it's a punishment or a deterrent imposed against certain individuals that are designated or named by the UN Security Council. Okay? Now, to obtain a freeze order, the AMLC must file an ex parte petition to freeze. Okay? An ex parte petition to freeze, and file that petition with the CA. The CA will now have 24 hours to act on that application, and the CA will only grant the petition if it finds probable cause that any monetary instrument or property is in any way related to an unlawful activity. The grant by the CA of the freeze order triggers the duties of covered persons, and the four major ones being to implement the freeze order, to freeze and report related accounts, to furnish a copy of the freeze order to the owner or holder of the account, and to submit a detailed return to the AMLC. Specifically, upon receipt of the freeze order, the covered person has to implement it by immediately freezing the monetary instrument or property and desisting from allowing any transaction, withdrawal, deposit, transfer, removal, conversion, or any other movement, concealment, or other disposition of the subject monetary instrument or property. Okay? So there should be no movement of the money. It should be frozen immediately. Likewise, in case of a freeze order for related accounts, these shall be frozen once verified to be related to the monetary instrument or property subject of the freeze order, and relevant transactions of related accounts shall be reported to the AMLC as suspicious transactions. Further, the covered person shall immediately furnish a copy of the freeze order on the owner or holder of the monetary instrument, property, or related account, and within 24 hours from receipt of the freeze order, the covered person must submit to the CA and AMLC a written, detailed return on the freeze order containing such relevant information such as the names of the account holders, value of the monetary instrument or property, date and time when the freeze order was served, and others as provided in the IRR. Okay? This freeze order shall be limited only to the amount of cash, monetary instrument, or value of the property that the CA has found to be considered as proceeds of or otherwise related to an unlawful activity. So, the freeze order will not apply to amounts in the same account that are in excess of the amount as determined by the CA. This freeze order shall be effective immediately, but its effectivity is only for a period of 20 days, within the 20 days, the CA must conduct a summary hearing to determine whether or not to lift the freeze order or to extend it for a total period not exceeding 6 months. So that's the longest period for the freeze order, 6 months. Once this freeze order is issued, only the Supreme Court and no other court can issue a temporary restraining order or TRO or injunction against the freeze order. So as you can see, the freeze order cannot last forever, especially given its nature as a provisional remedy. Its purpose is only to hold the dirty money so the criminal cannot escape with it while giving the authorities enough time to file the appropriate case, such as prosecution, civil forfeiture, or whatever other appropriate case may be. However, so that the authorities will not take their time, there is a limit, such that if there is no case filed against a person whose account has been frozen within the period determined by the CA not exceeding 6 months, then the freeze order shall be deemed ipso facto lifted. Wala na. Okay? But, what if the person feels that the freeze order was wrongfully issued against them? Do they have any remedy? Yes, a person whose account has been frozen has the following remedies. First, they may file a petition to determine the basis of the freeze order according to the principle of effective judicial protection, and they file that with the CA within 20 days from the issuance and during the effectivity of the freeze order. They may also file a motion to lift the freeze order, and the court has to resolve this motion before the expiration of the freeze order. Now, in case the freeze order was imposed on an account that is used for payment of salary, rent, suppliers, and or taxes in the ordinary course of a legitimate business, the person may apply to lift the freeze order by submitting a bond in an amount equal to that subject of the freeze order, the purpose of which is to secure the payment or enforcement of any order or judgment that the AMLC may recover in the case relating to the freeze order. In the meantime, the person whose account was frozen is allowed to withdraw such sums as the AMLC may determine to be reasonably needed for monthly family needs, sustenance, including the services of a lawyer, and medical needs. To emphasize, the freeze order that I just discussed can only be granted by the CA. However, there are cases when the AMLC has the power to issue freeze orders without a court order, but these are not strictly governed by AMLA, but rather by Republic Act number 10168 or the Terrorism Financing Prevention and Suppression Act of 2012 or TFPSA, and Republic Act number 11479 or the Anti-Terrorism Act of 2020 or ATA, as well as their respective implementing rules and regulations. However, since our discussion for this series is confined only to AMLA, I will not be discussing the TFPSA or ATA or their IRRs here. Maybe we can just discuss these in a different series in the future. However, briefly, under the TFPSA, the AMLC may, upon its own initiative or at the request of the Anti-Terror Council or ATC, may issue a freeze order if there is probable cause to believe that the property or funds are in any way related to financing of terrorism or terrorist acts. The AMLC may also issue a freeze order against designated organizations, associations, groups, or individuals in order to comply with international terrorism-related resolutions such as from the UN Security Council. Under the Anti-Terrorism Act or ATA, the AMLC may, again upon its own initiative or at the request of the ATC, issue a freeze order either upon issuance by the court of a preliminary order of proscription or in case of designation by the ATC of persons, organizations, or associations as having committed, attempted, or conspired in the commission of terrorism and associated or related acts. Ultimately, the purpose of such freeze orders by the AMLC is for the purpose of implementation of targeted financial sanctions related to the financing of the proliferation of weapons of mass destruction, terrorism, and financing of terrorism. In any case, if the circumstances surrounding the issuance of a freeze order warrant, the AMLC may initiate civil forfeiture proceedings to preserve the assets and to protect it from dissipation, which is actually the last remedy for today's discussion. Specifically, civil forfeiture proceedings refer to non-conviction-based proceedings aimed at forfeiting or confiscating in favor of the government monetary instruments or properties related to an unlawful activity or money laundering offense. This is different from criminal forfeiture, which, as I discussed earlier, is promulgated together with the judgment for conviction in criminal prosecution of money laundering offenses. So, criminal prosecution and forfeiture is conviction-based and requires proof of guilt beyond reasonable doubt, while civil forfeiture proceedings do not require conviction but only preponderance of evidence. To institute civil forfeiture proceedings, the AMLC must first determine that probable cause exists that any monetary instrument or property is in any way related to an unlawful activity or money laundering offense, upon which the AMLC shall file through the Office of the Solicitor General a verified ex parte petition for forfeiture with the Regional Trial Court or RTC. Now, I will not go through the full procedure since this is just an overview and procedural matters are actually best left to your lawyers for actual practice. But if you are interested, you can read up on it in Administrative Matter numbers 5-11-4-SC and 21-3-13-SC. Note that these are subject to future amendments but are current as of the time of this recording in July 2023. Take note, however, that the petition may include a prayer for the issuance of an Asset Preservation Order or APO, which is a provisional remedy aimed at preserving monetary instruments or properties in any way related to an unlawful activity or money laundering offense during the pendency of civil forfeiture proceedings. If such an application is granted by the RTC, then the APO shall be effective immediately, forbidding any transaction, withdrawal, deposit, transfer, removal, conversion, concealment, or other disposition of the subject monetary instrument or property. If they disagree with the issuance of the APO, then the person whose monetary instrument or property has been preserved may file a motion to discharge the Asset Preservation Order. And just like the discussion on the freeze order earlier, if the APO is imposed on an account used for payment of salary, rent, suppliers, and or taxes in the ordinary course of a legitimate business, then such person may apply to discharge the APO by submitting a bond in an amount equal to the value of the money or property subject of the APO for the purpose of securing payment or enforcement of any order or judgment that the AMLC may recover in the case relating to the APO. Note further that neither criminal nor civil forfeiture can be defeated by the alteration, destruction, concealment, or otherwise hiding the dirty money itself or property. No? Specifically, the court is empowered to enforce the order of forfeiture in both criminal and civil forfeiture cases by ordering the offender to pay an amount equal to the value of the monetary instrument or property if the order of forfeiture cannot be enforced due to any of the following reasons. Okay, any of these reasons. First, the monetary instrument or property cannot with due diligence be located, or it has been substantially altered, destroyed, diminished in value, or otherwise rendered worthless by any act or omission directly or indirectly attributable to the offender, or it has been concealed, removed, converted, or otherwise transferred to prevent it from being found or to avoid forfeiture, or if it is located outside of the Philippines or has been placed or brought outside the jurisdiction of the court, or if it has been commingled with other monetary instruments or property belonging to either the offender himself or a third person, thereby rendering the same difficult to identify or be segregated for purposes of forfeiture. Again, in case the forfeiture order cannot be enforced due to any of those reasons I just mentioned, then the court may instead order the offender to pay an amount equal to the value of the said monetary instrument or property. Finally, note that AMLA's Section 16 as amended sets forth the prohibition against political harassment. Specifically, during an election period, no case for money laundering may be filed against a candidate for an electoral office, and no assets shall be frozen, attached, or forfeited to the prejudice of a candidate for electoral office. So that's it for an overview of the legal remedies under the Anti-Money Laundering Act of the Philippines as amended and its implementing rules and regulations. So I hope you may have learned a thing or two, and I hope to see you next time. See you soon. Bye.